As a Kentucky injury lawyer, I'm never prouder of the work I do on a case for an injured client than I am on a case where the client initially calls me and thinks they have no shot or not much of a shot at all at winning their case. They've been in an accident or going through a rough time, and in their mind, it may be even hopeless to call an attorney. To teach you the points I'm going to cover in this video, let me tell you the story of my past client, Andy. Andy was in a motor vehicle accident in Kentucky where the other driver came over into his lane of travel and struck his vehicle. The other driver was clearly at fault. Andy unfortunately, however, discovered that the other driver had no insurance on his vehicle and was likely what we call judgment proof. When someone is judgment proof, it means that person lacks significant income or assets, and therefore, even if you won your injury case in court, you likely will never collect any money against them. Pursuing an injury claim against a judgment-proof person, in my opinion, is worthless and a waste of time. Since Andy was in a car accident caused by a likely judgment-proof person, it put Andy in a bad spot. You see, Andy suffered injuries in the car accident in which he sustained damages, including medical bills and pain and suffering. I recall speaking with Andy shortly after his accident. Andy sounded hopeless, but he still wisely thought it was a good idea to contact my office even though the other driver had no insurance on his vehicle to cover Andy's injuries. I asked Andy if the vehicle he was driving was insured by insurance. Andy said yes and advised that he was driving his mom's vehicle. I then asked Andy if he knew if the automobile insurance covering his mom's vehicle had any uninsured motorist coverage. He advised that he was unsure. He then asked his mom as well, and his mom thought they had such insurance coverage on the vehicle, but was ultimately unsure. Uninsured motorist coverage is insurance coverage that protects anyone that occupies the vehicle from bodily injury caused in a car wreck caused by an at-fault driver that does not have automobile insurance or when in a wreck with a hit-and-run driver. So what I did next in Andy's case was I went ahead and requested the declarations page of the insurance policy from the insurance company that insured his mom's vehicle. The declarations page is the page of an insurance policy that states the different types and amounts of coverage covering the vehicle. Once I obtained a copy of the declarations page for the insurance policy covering the vehicle, I was able to discover some very good news. Upon review of the declarations page, I found out that the vehicle had uninsured motorist coverage on it. This was great news for Andy. When I first told Andy the news, Andy was a bit hesitant at first to file an uninsured motorist claim with his mom's insurance company. He was afraid his mom's insurance payments might increase, but Andy and his mom had nothing to worry about. You see, Andy and his mom did not have to worry about their insurance company raising their insurance premium rates. That's because there is a law in Kentucky that disallows insurance companies from raising insurance premium rates when their insured files a claim under the policy, such as an uninsured motorist claim, so long as it is determined that insured is not the at-fault cause of the accident. And since Andy was not the at-fault cause of the accident, Andy and his mom had nothing to worry about. Per Kentucky law, since Andy was not at fault for the accident, his mom's insurance rates could not be raised due to filing the uninsured motorist claim. So when I explained this to Andy, he was on board with pursuing the uninsured motorist claim. We then collected Andy's medical records and bills. Next, I sent a written demand letter along with all the evidence we had obtained in support of Andy's case to the insurance company, demanding that the insurance company pay out the uninsured motorist policy limits. In response to my written demand letter, the insurer agreed to pay out the policy limits of $100,000. And since Andy also got $10,000 in no-fault insurance benefits to go towards his medical expenses, his total recovery on the case amounted to $110,000. Andy was ecstatic. When he first spoke with me, I could tell he thought there really wasn't much I could do for him. I highly suggest that anyone injured in a car accident contact an injury lawyer, even if you think there is not much of a chance of being compensated. Every single injury lawyer I know, including myself, offers injury victims free consultations, so you really don't have anything to lose when you consult with an injury lawyer. Car accident cases and insurance coverage can be complex. Do yourself a favor and consult with a lawyer. Get a legal opinion as to whether or not you have a chance at a payday. The thing is, now that you know you shouldn't give up on your injury case, even if you think your injury case may be hopeless, if you end up having a viable injury claim, there are certain things you should know about your case if you want to have a successful claim leading to a big payday. And in this video about to pop up right here, I will tell you what you should know about your injury case if you've been injured in Kentucky. Lastly, if you've been injured in a car accident, slip or trip and fall incident, or dog attack incident in Kentucky, remember to don't wait, call Tate.